Several years ago, I ended up watching a documentary, and it fascinated me. And it was a documentary that took me and viewers behind the scenes of what was then a very high profile and controversial murder case. And the murder case involved a well-known and successful artist or a novelist. And the case had all kinds of interesting twists and turns. And one of the things that fascinated me was that they took us actually behind the scenes into the lawyer's house, discussions with the lawyer and the team. And it was a case that as I watched it, I thought to myself, they're going to win this case. The man deserves to be acquitted. And the lawyering was absolutely brilliant. And that was the prosecution of Michael Peterson. And I am blessed to be joined by David Rudolf, who was Michael Peterson's original trial lawyer, and his wife, Sonya Pfeiffer, here on Killer Cross-Examination. Welcome to this podcast, both of you.
Thank you, Neil.
Thanks, Neil. Good to be with you.
So I just want to get a little bit of background. So I'm going to say that you're the first tandem that I've interviewed. So tell me a bit about each of yourselves. I'm well familiar with David and his law practice. I'm a big fan. I'm sort of a nerd in that way. I really happen to have lawyer baseball cards almost on my wall. And I become a fan of yours, Sonya, through the podcast. But tell me about how you guys met and your backgrounds and what you're up to today.
Well, it begins with the Michael Peterson trial. So I was a television news reporter for 12 years before I went to law school. And in 2000, I was working for a television station in Raleigh-Durham, WTVD, and I got assigned to cover the Peterson trial, which at the time was, covered by national networks, every local station, everyone across North Carolina. It was a case where if you were on it as a reporter, you couldn't miss a thing. So you naturally developed relationships with people throughout the course of that, both the investigation beforehand and the prosecution and the trial itself. And so David and I got to know each other during the trial. I always joke he didn't like me very much then. He tries to dispute it, but we don't need to go into the details of the phone calls I got after my 6 o'clock live shot when it was a story he didn't like. But after that case, he and I just continued our relationship. From my point of view, I was going to law school. I was doing that so that I could be a reporter who covered the law and justice. And I thought that would be a way to get out of the day-to-day in local news, which was really crime, traffic, and weather. It was just starting to devolve into that. And it seemed to me like a great idea to keep in touch with this guy who could be not only a helpful resource for me as I went to law school, but somebody who might be a good source going forward when I became, a national correspondent for Dateline or something like that. And that's not how it ended. I ended up going to law school.
How did it end?
Well, I'm still a source.
That's true.
Yeah, okay, well, no pillow talk, but I didn't talk about that. But you two are married.
We are married now. Yes.
And we have a 10-year-old daughter.
Mm-hmm. And you practice together.
Yep.
And you have other endeavors that you're currently involved in. And I want you to, before I get to some of the stories about lawyering that you've seen and what you think is some of the good and bad styles and tips for lawyers, tell me, if you would, how you came about your current project, which is a very popular, informative, and I think important podcast. So what's it called?
Well, it's called Abuse of Power, which is something that I've grown to find to be a really important concept in the criminal justice field. And over the years, I've just seen numerous examples, as I'm sure you have, Neil, of police and prosecutors and even judges abusing the power they are given in ways that really undermine the fairness of the system. And so that was the genesis of the idea. We happened to connect with Ross Dinnerstein, who did Innocent Man on Netflix. And from there, the podcast grew, and now it's been sold to Audible. Audible is going to be producing the second and third seasons. We've just started taping season 2. The format will be a little bit different, but the stories are just amazing.
And I
How
think
do you find the cases, or do they find you?
Well, it's a combination. Some of the cases we knew about just from either our personal experience or people who we know and have talked to in the past. Others were found by Ross and his staff, just doing some research. And the latest episode comes from a lawyer, a human rights lawyer in Great Britain, Clive Stafford Smith, who is well known in wrongful conviction circles, and he did this case. He's been on this case for 28 years and still going. So he's well equipped. He's almost doubled my longest foray into representing somebody, and he's a central figure in the podcast, as well as his client and all the various witnesses who he's dug up over the years.
How many cases have you covered, Sonya, since you started the podcast?
in the podcast itself, you mean?
Yes.
So in the first season, we covered 10 officially. Each episode was its own case. We did an additional, what we called a bonus episode, because we were launching the podcast soon after the murder of George Floyd. And we felt as though we were tone deaf to not talk about that case and the abuses we saw. And indeed, we saw in the conviction and sentencing of Derek Chauvin that abuse of power was one of the aggravating factors for which he got a sentence above that presumptive 12 years. So 11 in that first series. And this second series, as David said, is a little different because we decided to just focus in on one case. I think it allows our listeners to go deeper into the story and to learn along with us and sort of experience a case step by step and analyze various abuses at different points in time during a case.
Do you two, you still are practicing law?
Yes.
Right? And is the focus of your practice criminal defense, civil rights, or a combination of?
Well, I think it's still somewhat of a combination, although in the last 10 years or so, I've really developed a niche into wrongful conviction work. And so I would say that at this point, probably 80% or more of my practice is representing people who have been exonerated. And we're now trying to get them compensation for the wrongful conduct that put them in prison to begin with. And that's really what I've been doing primarily for the last 10 years.
And for me, I probably have a little more criminal in the work I do, but we tend to, if I work on a criminal case or if we work on one together, it does tend to be a more complex case, a larger case that you can really stay focused on. As I'm sure you and many of your listeners are aware, the more you have in terms of caseload, the less attention you can really give to each case.
Right. So let me ask you this, and I'll ask it to both of you. So one of the questions that I have often posed to jurors during voir dire is I try to have them put themselves on a spectrum of what their opinion is of the legal system. Some people think that it works all the time, and they're just stunned to hear about abuses, and they just sort of brush them off, and they think, no, there's got to be some other explanation for it. And on the other end are people who just disbelieve the system altogether. How do you communicate that to jurors given all the cases that you've seen, that the ones you've taken, the ones that you've turned down, the ones that you talk about on your show? How do you communicate to jurors in a criminal case or in a civil case?
Well, I think that a lot depends on how much latitude you're given in voir dire, doesn't it?
Are you permitted voir dire in North Carolina?
We are in state court. Obviously, in federal court, it's a different story. But in state court, we're given fairly wide latitude if you know what you're doing. If you don't know what you're doing and you're wasting time, judges are not terribly patient about that.
You don't think the bumper sticker question works with? You don't think the judges? From the judge, I watched that and I thought every judge I know that I've ever seen a lawyer try the bumper sticker question, they just okay, counsel.
That's right.
3 more minutes.
Right. So, what I try to do is I try to sort of make it real for them. So I'll say something like, now there's been a lot in the news lately about, police interactions with citizens and about the justice system. And some people take the view that the justice system is really working just fine, and we really don't need to change very much. And other people take the view that the justice system is broken and we need some major reforms. My question to you is, give me a sense of where you are in that spectrum. And then when they tell me, then my next follow-up question is, can you explain why you feel that way?
That's excellent. So I love that type of voir dire. I love, is that the way that you've been doing voir dire, David and Sonya, for your entire practice?
No, I'd have to say, Neil, that to be honest, the first trial I ever had, voir dire was a disaster for me. I mean, it was just a disaster.
Okay, why?
Because I was asking, yes and no questions, and I didn't think about where I was going to take it or why I was asking the question. I had a list.
You know what the burden of proof is, and it's presumption of innocence, and you know what reasonable doubt means. It means reasonable, and it means
right. Yeah. So it was just awful, and I actually got a not guilty in that case, but.
Because they felt so sorry for you.
Probably so.
Believe it or not, I know some lawyers that have gotten a lot of not guilties, and we sit there and we scratch our heads. And I think it's because the jury goes back and they say, "We got to do a good job for this guy."
Right. So actually, the truth of the matter is, I went back after that, and I thought to myself, I never want to go through another experience like that again. And so I spent a lot of time thinking about what had gone wrong and how I could make it better. And so I came up with a I don't know if system's the right word, but an approach that really focused in on open-ended questions and letting the jurors talk, and knowing if they say this, I'm going to go in this direction, and knowing if they say that, I'm going to go in that direction. And that was the key, because you need to know where you're going, where you want to take something when you start asking a question. You need to know sort of what are you trying to find out, and how are you going to explore that depending on what their answer is. And so literally I had a tree, a decision tree. If they say this, you ask that. If they say that, you ask this. And then gradually over the years, I just got more comfortable talking to jurors. And that's really the key, as I'm sure you know, Neil. You got to get into a conversation with jurors. You got to be vulnerable. You have to tell them that you have your own biases and prejudices, that you couldn't sit on every case because of your own experiences. You need to encourage them to disclose the things that they might be embarrassed about. And the only way you can really do that is by disclosing the things that you might be embarrassed about. So you're all sort of in the same position. And that's been really successful for me.
Let me add from my experience.
I was going to ask you, because, you started you have got a totally different background. I mean, you've got a reporter background, and then you went to law school, and then obviously. So tell me your view of it, your perspective.
Well, it's interesting to listen to David talk about his early experience in voir dire, because I think if you ask anyone who's a news reporter, whether it's newspaper, print, or broadcast, radio, you learn very quickly the worst thing you can do is ask a yes or no question. And so many of the things that lawyers learn in voir dire, reporters learn just in their day-to-day work. I mean, by the time I had done 3 stories, in my early 20s as a reporter, I knew the way to ask questions. And then you also learn the way to connect with people. And so voir dire, I think, has always been one of my great strengths at trial, because I know how to connect with a person. I know how to talk to a group. I know how to ask questions. And, David talked about a decision tree. You get to the point where there's a level of comfort that you don't need the tree. You know the information you're trying to get, and you begin to synthesize the answers, and from those answers figure out where to go next. I think that one thing people underestimate is the value of practicing on friends and family. We all do these mini focus groups when we have a case, right, and we want to know how people are going to respond to facts. Don't forget that in something like voir dire, you can do the exact same thing with friends and family. And you
Right.
talked about the scaled questions. Look, I was fortunate when I became a lawyer. Not only did I already have more than a decade of experience in talking to people and forming relationships quickly with people who seem to have nothing in common with me, but I also had a resource. I was married to David. I had gone to incredible CLEs. I knew David Ball and his strategies for how to ask questions that gave people a spectrum on which they could answer. But I also think if I didn't have that, I'd be able to take advantage of outings with friends, of family dinners, where I could sort of pose these questions and try it out on them. And I think that's something that
It's difficult. People don't, it is, I encourage people, and I do it all the time. The question people always want to ask me is, how can you represent that sort of person? And do you ever defend someone, that is guilty? And I, sort of smile at that and, have my own kind of, depending upon the person, my own quick-witted, pithy, or sympathetic ways of kind of answering that. But I don't think people realize how much we do use everyday communications to, one, better our people skills, better eye contact, and to try to listen and get feedback. So those are great tools. And I think people a lot of times are afraid to talk to their peers. I'm not talking about practicing your opening. I'm talking about where they're afraid to do something and to look or sound bad. And if you're afraid to look or sound bad with the people who aren't going to judge you, you can only imagine, how you're going to end up looking and sounding in front of a jury who is watching your every move. David, where are you from? Where were you born?
You can't tell. That's good. That's good, Neil. I'm very happy by that.
I could tell a little bit, but I don't like to ever. I'm guessing you were born somewhere in the northeast, somewhere around a big city, somewhere probably that has an island. And
now you're just guessing wildly. I was born in New York City and grew up part of my youth in Queens, and then moved out to Long Island.
Long Island.
Long Island, yes.
Yes, when my family was when I was in third grade, and I've worked the rest of my life to try to ameliorate that accent.
What made you get into to want to become a trial lawyer? Did you always know that was where you were destined? And what do you think makes you the trial lawyer that you are today?
Well, that's a loaded question. Maybe I'll let Sonya answer the latter part. But no, I was not one of these kids who thought, oh, gee, I want to get up there and be a trial lawyer. I grew up in the 60s and 70s, and Vietnam was going on. Once I graduated from college, I needed to stay in some school or else go to Canada. So I was debating between political science and law school, and ultimately decided that law school gave me more options. So I had no idea that I was going to become a trial lawyer. But then I got there and I had a small section in criminal law, which was great. I had Irwin Younger for evidence, which was amazing. I did a clinical program where I represented.
You're talking about one of the original authors of one of the 10 commandments of cross-examination.
That's
right?
Exactly. And he was just, imagine sitting there in class 3 times a week listening to him.
Bailey once asked him, hey, are there really 10? And he said, I'll give you clear. I think there are like 7, maybe 6, but 10 sounds better.
Exactly. And then I had this clinical program where I represented people who were charged with misdemeanors. And that's where I did that first trial. It was a 6-person jury. I had my supervising attorney sitting next to me, trying to help me get through this voir dire. And I got a not guilty. And that was it. I mean, as soon as the not guilty came in, it was like, okay, I know what I'm doing the rest of my life.
You got the rush. You got
exactly. Exactly.
It's like golf in a way, and you hit a great shot, and that's what you remember, is you want to sort of that great feeling of being able to duplicate it, but you really change someone's life.
Yes.
So I guess you deferred to Sonya about what makes you the great trial lawyer that you are today. So if you want to let her answer that,
Well, I'm curious to hear what her answer
No,
is.
I am too.
Let's be clear what this is about. That he needs me to stroke the ego a little bit and explain to everybody what makes him so great, which I'm happy to do.
I'd love to hear it. I thought he had great patience. I will tell you. So some of the things that I watched in the Peterson trial, I know that was not your first high profile trial. I know you've had others before it. I thought some of the things you did in the trial were incredibly ingenious, including when I think it was the fire, was it the tong or like the fire?
The blowpoke.
What's that? The
blowpoke.
The blowpoke. And it was identified, and you called in a professional photographer to come in and take what were some of the most high definition photos of the cobwebs and the dust, and just created the image with that picture alone of how long it had been sitting there.
Right.
Clearly it hadn't been picked up and used and put back. I thought that was brilliant. And I thought but one of the things that I was so surprised at was you were seated the whole time during the trial, which is a totally caught me off guard.
You have to in North Carolina.
North Carolina thing. Mm-hmm. Mm-hmm.
Unless you have a piece of paper in your hand.
And then you can stand up.
If you have a piece of paper in your hand and it looks like you're approaching the witness, you can stand up and then you can change your mind and go back to sitting. But other than that, in North Carolina, you have to be seated during your direct and cross examinations.
Have you gotten used to that?
I have. It was, coming from New York, it was a really tough transition, to be honest. And there are a number of times when I ask a judge, would you mind if I stand? And especially early on in my career, well, that's what I was used to. Now it really doesn't matter to me. I can cross-examine as effectively, I think, sitting down as standing up. Now, the one thing I will tell you that I learned this from somebody else, we all steal our best things from other people, of course. During voir dire, I pull my chair out from behind counsel table and sit right in front of the jury. Now, obviously, I asked the judge's permission, but there is nothing between me and the jury. There are no notes. I'm just sitting there, sort of vulnerable in a chair in front of these people asking questions. And I think that's part of, you want to eliminate the barriers in order to communicate most effectively. And I think that's something that doesn't necessarily occur to most people, but it's been really effective for me. The other thing I just want to mention, if we're talking about voir dire for a second, is I had a federal judge in one of my cases give the analogy to the jury that he had gone to the University of Tennessee and he could referee a Vanderbilt Duke game, no problem, but he couldn't referee a Tennessee Vanderbilt game. And it really sort of brought it down to a level that the jurors could understand. So again, it's just a question of communication.
So tell me, so that analogy I'm going to come back to, because I've had a similar we've used similar analogies here because we've got real rivalry games here in Michigan. I've got Michigan, Michigan State, Michigan,
right.
State, although Michigan, Ohio State hasn't been much of a rivalry lately. So Sonya, I deferred to you. You were going to tell me, you were going to do some ego stroking and tell me why you're such a great lawyer. So the floor is yours.
Well, sure. No, you actually teed it up well when you talked about what you observed on the staircase and what impressed you. Because, one thing I think is important for people to understand, particularly attorneys who have watched the staircase or who will watch the staircase and see the level of lawyering that, was presented through David and his team. It can be very intimidating. You feel like there's no way I could do that. But what's critical to understand is the level of preparation and dedication. As a reporter covering that case, it was clear to me that this was an excellent lawyer. He did lots of things really well. Now that I know him and we are married and we've worked on cases together, what makes David so good is how much he focuses on every detail in a case. There is not a page that goes unturned. If there are a million documents to go through, he'll go through a million documents. It really is a level of dedication and, frankly, obsession, that you cannot miss something. And I think that kind of preparation, knowing all of the evidence, is critical. And then what comes into play are the years of experience, the sort of critical reasoning that exists. But then I think that David does have a talent for strategizing. And again, that comes with time. But I think that one of his many gifts is being able to look at a case and look at the evidence and look at the options and alternatives and come up with a way to present something, whether it's to a jury, whether it's in a deposition, whether it's, on trial and cross-examining a witness. It's about strategizing and really thinking through that process. So
how about you? So let me ask each of you, Sonya, how would you characterize everybody has a style, right? I mean, there's the folksy style and there's the Columbo style. And then there are the guys in New York that are, like, I interviewed Jeff Lichtman and I asked him, how would you describe your style? And he goes, suffocating. So Sonya, how would you characterize your style of courtroom lawyering? And I know it changes from moment to moment and it changes based on the case, but all in all, if you have to put yourself in some category, you got to put yourself in a shoehorn yourself somewhere. What's your style?
No one has asked me that question before. And I'll be interested to see what David has to say about my style, because honestly, I think my style is just being authentic. I hate to use such an overused word right now, but I am comfortable and confident. And if I screw up and you're the jury and you see me screw up, you're probably going to know it because it's going to show on my face. If I'm asking you as a witness questions that are challenging, that's going to come through. I think part of that is my reporter training, that you communicate a lot through body language and through your voice tone and quality, and whether you drop back a little bit or whether you're really forward with somebody.
Change up your tone? Do you
absolutely
highlight and emphasize things by toning it down, and then you're not always at level 10 or level 11?
Yeah. And I don't mean to say this in a dismissive way, but there is an acting quality about what I do. And that also, that you've listened to our podcast, that comes through in my interviews. You hear in my voice when I'm talking to somebody, if there's a sense of urgency, if we're talking about something and I'm upset, my voice is more like this. But if I'm talking to Christine Bunch about what it was like to hear that her son died, then it changes. And so my style is, I don't know, I guess I'm
flexible.
Okay.
Yeah.
It's because I got this label as a young lawyer. They started calling me the Rottweiler. Play on the word Rottweiler.
Yes. Yes, we get it.
Because I was aggressive. And the funny thing is that when people see me, there are times where I've been aggressive, but there are also times where, I've been fiery at times, but there are times where I'm, just, my goal is just to let the witness just chip up all over him or herself and just give them the opportunity to do that. So how about you, David? How would you characterize Sonya's style in court? And you can't say the same thing. It's not fair.
All right, I can't say the same.
Don't say authentic and flexible. Let me hear, why would you, if you were a prosecutor, what about Sonya's style of lawyering, her approach to cases, whether it's opening, cross-examination, whatever it is? What about that would you say to yourself, you better watch out?
Well, I think what you better watch out for is how well she communicates to the jury, because we're sort of a really good team. She's the one person who can tell me in the middle of a cross, I think you made your point. Because I'm really having fun, and the jurors sort of sitting there tapping their fingers. They've gotten it.
And they're about to turn.
Right. And Sonya will say, I think they've got your point. Sonya's just...
When judges say that to me and they go, Mr. Rock kind of approached the bench, and I go, sure. They go, I think we get the point. I'm like, well, will you tell them? Just can we look over and just confirm?
We just lost your audio.
We lost your audio.
Oh,
there you go.
Yeah.
So, okay. So
anyway, so Sonya is just an incredibly effective communicator. And I won't use the word flexible, although that was my word. But she adapts really well to whatever the situation is. I'm a little bit more one speed, to be honest. I tend to be intense, and I tend to be intense more than I should be, probably. I think
very serious. Now, you looked very serious. I mean, obviously it was a serious case, but you looked very serious during the Peterson trial. You just had a look like, I guess intense is a very good word. It didn't come across like you were angry or hostile. And I think that's a skill that I think some lawyers need to figure out how to, if they're intense, they have to figure out, because you still look like you were in control.
Right.
Like you weren't losing it, but you were intense.
Yeah, and I think that's just my natural personality. One of the things I learned a long time ago is that I have to be who I am, and I can't be you, and I can't be, Percy Foreman, and I can't be F. Lee Bailey. I am who I am, and that's, if I try to do something else, it's just going to come off as unauthentic.
You play any sports, David?
Well, growing up, I played soccer, but not very well.
Listen, he's so intense that our daughter is a little worried about the fact that he doesn't know when she's joking. This is sort of an ongoing thing right now.
It's so funny because he looks like the kind of guy that if he would say, "Hey, do you want to play like a game of like squash or racquetball?" I would say, "Sure." And then he'd get out there, and then he would be the guy that would be pounding me into the wall and.
Correct.
The ball in the back and go, you're interfering.
Yes, yeah. You're exactly right, Neil, and I apologize for doing that to you.
All right, so I'd like to hear. Give me a good cross-examination story, one that you are particularly proud of. And I don't care what case it was. Each of you a good cross-examination story that you look back and you think that when you sat down and you still think to this day, man, I did that one well.
Yours is the best. He just has the best.
I've got the perfect one.
Okay.
I hope you think about someone.
Of course I am. How could I think about anything else?
So, well, it could be from Peter, from
I'm thinking
Carruth.
Carruth.
You're thinking Carruth?
There's no better cross-examination story.
Owens is a good one too.
Let me just tell the jurors who don't know that one of the things that I took away that lawyers still do to this day is, then have always stolen from you, is your top 10 list of reasonable doubts. And of course, you add in there that these are the 10 that you identified. Of course, the jurors may see another million. But at the time, what many don't realize is that David Letterman had a very popular top 10 list on his, which I thought was a great play on popular media. So anyway.
Well,
listen, I'm going to give up. I'm going to give up my story about cross-examination because both of his will beat whatever I have.
Okay.
So you should just tell both of them.
All right, I'll tell both.
Yeah.
So during the Carruth case, Rae Carruth, I represented Rae Carruth, who was a professional football player charged with contract killing of his then pregnant girlfriend. He was facing the death penalty. And the prosecution made a deal with the hitman, the guy who actually shot this woman. And Van Brett Watkins. And this guy was like 6'5", 260 pounds, shaved head, an intimidating figure.
Okay.
And mentally unstable. And I had this whole cross-examination ready for him until he flipped and became a state's witness. And so I decided I was going to put him on myself as an adverse witness because my whole theory depended on the jury understanding that this guy had just acted on his own out of anger. And I needed to let the jury see him and understand that he could do this without anybody agreeing to pay him anything or to do anything.
And let me just provide a little context that the defense theory was that Van Brett Watkins was pissed off because Rae owed him money. A drug deal had gone bad. Whereas the prosecution's theory was that Rae hired Van Brett Watkins to kill his girlfriend. So that's the context in which this cross happened.
Right. So anyway, I called Van Brett Watkins to the stand and I started cross-examining him about all the violent acts that he had committed in his life. And then we got into the fact that he claimed to be a hitman, but on the night of the murder, he was out trying to find a gun to commit this. This was supposed to be a planned hit, but here he is, like an hour before the shooting, calling around, asking people if they have a gun. And so at some point in the cross, I said to him, so Mr. Watkins, if I understand you correctly, you were a hitman without a gun. Is that right? And he said, I didn't need a gun. I could kill you with my bare hands. I'm 286 pounds, and I could rip you limb from limb like a little rag doll.
Wow.
And I said, thank you very much. And I sat down, and the jury acquitted Carruth of the murder.
Did every juror, when he say that, lean back?
Oh no, they had already leaned back. That during the cross, he was getting angrier and angrier. And actually, the judge in the middle of the cross had brought in some extra bailiffs. So he had a bailiff behind him. He had a bailiff behind the witness. The jurors had moved about 3 or 4 feet away from the witness stand. They had all sort of shifted their seats. And he had stationed the bailiff in front of Van Brett Watkins. And afterwards, the judge told me that he was just convinced that Van Brett Watkins was going to come out of the chair and try and get at me.
So that is a rare moment in court where you get, that's like a Perry Mason Matlock moment where the guy just implodes and then explodes all over the entire case.
It was just like A Few Good Men. You can't handle the truth. It was
brilliant.
That.
It was unbelievable. The second one is a little less dramatic, but I was cross-examining a police officer who had engaged in a very suggestive lineup. My guy had been.
Well, this is a current case that we have.
It's a
wrongful conviction case.
Anyway, so my guy who ended up spending 43 years in prison before being pardoned. He was wearing a long black coat when he was arrested. And so somehow or another, although it wasn't in the original description of any of the perpetrators, the witness, the sole eyewitness, had added this black coat to his description. And so there's 3 lineups conducted by this cop, one after the other, same people. My guy is the only guy in a long black coat. Everybody else doesn't even have a coat on. And so needless to say, the witness picks my guy out 3 times in a row. So now we fast forward 30 years, and I'm cross-examining this guy. And I have the pictures of the lineups, which he doesn't realize I have. And so I start off, very nicely, and I say, well, when you put Mr. Finch in the lineup, did you leave his coat on? Well, no, I didn't leave his coat on. Well, why didn't you leave his coat on? Well, that wouldn't have been fair. Why wouldn't it have been fair? And he says, and notice these are all open-ended questions.
I was just going to say, these are all open-ended questions, which sometimes you can ask if the answer can't hurt you.
Exactly. And that's the rule. Not Irvin Younger's rule is a little bit wrong, but we'll get to that in a minute. So I say, well, why wouldn't you put a coat on it? Well, that wouldn't have been fair because, a witness is supposed to identify somebody by their face, not by their clothing. And so if I had put a coat on him, that wouldn't have been fair. I said, okay. And then I took out the photo, the first photo, and I showed it to him. And I said, do you see Mr. Finch there? Yes, I do. What's he wearing? He's wearing a coat. Is anybody else wearing a coat? No. I said, well, I thought you told me that would be unfair. He said, well, I didn't remember that. I said, no, I'm not asking you what you remember. We can see in the photo, right? Right. So would you agree that was an unfair lineup? Well, yeah. Then I took out the second photo and I said, take a look at this. You see Mr. Finch? Yes. Is he still wearing a coat? Yes. Is anyone else wearing a coat? No. I said, well, if it was unfair the first time, then it would have been more unfair the second time. And he said, well, no, not more unfair, just unfair.
Let me add this as
I love it.
a practice tip to what David did. He got lucky in that this cop at the beginning went ahead and said it wouldn't be fair. He set up for David what we can do in cross-examination of a police officer. Let's say that there was something the police officer did wrong, whatever, whether it's a lineup or whether it's interviewing two people at the same time. The thing to do in cross is to always start big, like draw the lens back. You took basic law enforcement training, didn't you? Yes, I did. Why was that important? Well, it teaches you the basics. That's right. And there's a chapter in there about this, isn't there? Yes, it is. And you completed that course. And so what you do is you set all of this up, and then you begin to narrow into what did or didn't happen. And I think that, in this case, the officer sort of offered up what the rule was. It's like starting with the rule or what the practice, what you're supposed to do. And then you begin, things that they can't possibly disagree with, because there it is in their training manual.
Well, and
and it's hard to disagree with how unfair that would be. I mean, he opted for what he thought was a safe harbor answer.
Exactly. And that's the point that should not be lost, which is it wasn't completely luck that he gave me that answer. He gave me that answer because he was trying to make himself look good, look like a good cop. And so I knew when I asked him the question, well, why didn't you put the coat on him? I didn't know the exact words that were going to come out, but I knew he was going to try to say something that would make him look fair, that would make him look reasonable. And so part of this is sort of putting yourself in the mindset of the witness and sort of figuring out, well, what's the witness going to want to say in response to this question? And that's when it's really safe to ask an open-ended question.
Right. I think we're all saying the same thing. David has just so much experience, but we're all sort of, for those who are, if they're young lawyers who are listening, I certainly am not saying that you can't ask an open-ended question, but you have to really be able to feel the moment and know that the open-ended question is not going to hurt you. Because what would that be? Would that be fair? And he said, no, that would be unfair. If he said, yes, that would be fair, that depends, I'm sure that you had a way that you were going to deal with it and could have quickly converted to leading questions that would have put him in the box.
Exactly. No, it's a question of being prepared for the unexpected answer and knowing.
When you are able to ask an open-ended question like that and have the witness give it up to you like that, it makes it a more profound gotcha when you go to but or however, or we'll then take a look at this, because you're now taking an exhibit, which is a fact beyond change, and you're now putting that right to the witness, comparing it to his answer.
Right.
So really brilliant. So let me, I could probably talk to you guys for hours, but I can't afford your billable hours. But I do want to, at the end of every podcast, first of all, I'm a big fan of yours, David. I have been for a while. Sonya, I've become a big fan of yours. And you're both such a great team, and I think have so much to offer. One of the things that I like people to do is to be able to find you or to reach out to you or to find the things you're doing, in the law and in the podcast. So let's start with your firm, and how would someone want to reach out to you if they wanted to reach out to you?
Well, the firm has a website, which is www.rudolfwidenhouse.com. I have a personal website that I sort of put up when The Staircase came out, which goes into some depth into sort of who I am and why I do what I do and cases I've worked on. And that's www.davidsrudolf.com. And then we're on social media, Sonya.
Now, there's one other way too to find me is I also own an art gallery here, and that's eldergalleryclt.com. And the gallery's real focus is on contemporary programming and artists who are addressing contemporary issues in their work. So in some ways, an extension of advocacy. But our social media is another way. I'm on Instagram, that's Sonya Pfeiffer. And on Twitter, it's the flip, it's Pfeiffer Sonya. I don't do that much on Twitter, although I probably should. And then David is on Twitter.
I'm on Twitter.
And what are you on Twitter? David S. Rudolf?
I don't remember. Just look me up on, you can look me up on Twitter.
And if they want to find the podcast, which is
Abuse of Power.
fabulous, it's an award-winning podcast. And I don't mean it is really, I've listened to them, and I'm a guy who doesn't have a lot of time to listen to things. And I've been just sat in my car, and people are looking at me like, you coming out? I'm like, yeah, one more minute. I want to hear how this thing ends. So what's the podcast and where can people find it?
So you can just go to Abuse of Power. I think it's abuseofpowerpodcast.com. And that will take you to all of the places where you can find it. You can go to Abuse of Power on Apple right now. I'm just going to double check the website so people make.
It's available wherever you download your podcast.
Well, and it's going to be on Audible, right?
Okay. So that's Audible is a big
it's an Amazon company, actually.
Yep. It's a big platform.
That's big time. That's
like podcasts, audiobooks.
Backyard to what is it called? The what's the big wrestling thing that they do? The guys MMA.
Yeah.
WWF.
No, that's not even in existence anymore.
Oh, geez, I'm showing my age. Okay, but yes, it is abuseofpowerpodcast.com. That's the website. And from there, you can link to anywhere, and you can read about the stories and a little bit about us also.
I am so appreciative that you guys took time out of your busy schedules. And I really encourage everybody to listen to the podcast. If you think the legal system works or works all the time, you really need to listen to David and Sonya's podcast, because they're probably the first season probably scratched just the very, 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 very surface of the issues in the legal system. And now they're going to go in depth with cases and take you behind the scenes, kind of like what happened in The Staircase, but they're going to take it to you behind the scenes week in and week out. You will absolutely be mind blown about the challenges that people face in court. I can't thank the two of you enough. And thank you so much for joining me, and thank you for being my guest on Killer Cross Examination.
Thank you so much.
Thanks, Neil. We appreciate it.
Have a good one.